It is so unbelievably dumb. I don't even know how to fully describe it.
This dude is an idiot. This dude is a moron. He's everything that's wrong with society and thinking that you can do a stupid action and talk your way out of it.
I follow.
All right, thank you. Anyone else in the subpoena list?
I mean, there's others that we have objections to, but I don't know if you want to address that right now, Your Honor.
Well, I'd like to have you put them on the record so that Mr. Brooks knows, and if he wants to respond now, that's fine. Otherwise, we can take it up a little bit later.
Then there was one of the parents of the victims, Kathleen Urell. She was not present at the parade, and it's really unknown what type of testimony he would want to elicit from her, so we would be requesting an offer of proof to establish the relevancy of those witnesses, Your Honor.
Do you want to address that now or have an opportunity to think about that and address it perhaps at the end of the day?
It's really nothing to think about. I think it's pretty clear.
What about this Kathleen Urell? I know she's on their potential witness list that was filed.
And that
To correct, I apologize for interrupting, but I did misspeak. She was at the parade, but she did not see, she cannot testify to anyone being struck or injured by the SUV other than her own children that she learned after the fact. And she cannot identify the driver.
All right, Mr. Brooks?
it's still relevancy there. She was at the parade, and as we just heard right now for the record, that she would be directly affected by it, by her family being victims in the matter. Also, she gave statements and she filed a report. I feel like her testimony would be relevant to the matter.
All right, I'll keep her on the list as well. The 35th count, the 36th count, the 37th count, the 38th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, to recklessly endanger the safety of Alice Urell, of Charlotte Urell, Vivian Urell, and Grayson Urell, under circumstances which show utter disregard for human life, and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes.
So I'm guessing that's, oh, I know what it is. Just give me one quick second, Your Honor, one quick second.
Go ahead.
Okay, I'm ready, Your Honor.
Go ahead. Call your next witness.
Kathleen Urell?
Urell? That's how I think it is. We'll find out. Ma'am, if you would please make your way to the witness stand. When you get there, please remain standing. Raise your right hand, and my clerk, Teresa, who's on my left, will swear you in. Go ahead and come all the way up. Thank you.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please have a seat.
Good afternoon, Miss Urell. Is it Urell?
Urell.
Urell. What do you do for a living?
I'm in workforce management for a call center.
November 21st, 2021. Directing your attention there. You recall that evening pretty well?
Off and on, sir.
That's fair. It has been a while. Do you recall what you were doing that evening?
Yes, sir.
And what were you doing that evening?
At what time?
Around 3:30, 4 o'clock-ish.
I was dropping off my children who were participating in the parade.
And did you yourself stay for the parade?
Partial parade, yes.
Partial meaning maybe a few minutes?
Until my group of children went by.
Okay. Do you recall where you were positioned during watching your group participate in the parade?
Yes, on North and East, right on the corner there.
North and East.
If you're going parade route, it would be on the right-hand side.
Just so we have clarification, can we pull up the exhibit? I believe it's 15. For the jury, and can you, using the touchscreen on your screen, can you point out exactly where you were positioned?
When I was watching it,
Yes, when you were watching it.
right on the corner, sorry. Oh, well, if you want to
Can you clear,
reverse it
can you
again,
clear
I'll do it
the
again.
arrow?
We'll clear it, you can do it again.
Yeah.
If you don't want, do you want the arrow?
Well, it was to the...
Clear it again.
Okay.
So it's a touch screen, so use your index finger and you can draw a circle.
Okay.
I was going to
Can
say
you clear
that.
Well, I mean, it was right there, but...
I was going to say a circle or a little dot if.
Well, I thought I would do that, but...
Yeah.
Oh.
Hold on.
Heavy
We'll do it
hands.
again. So press and hold while you draw.
Okay.
There you go.
And you said that would be approximately East Main and Northeast?
Correct.
And do you recall if those, well, there's side streets right there that you can see? Is that fair to say?
Correct.
And those side streets would be Northeast and Buckley, correct?
Correct.
Do you recall if there were barricades at those?
I can't honestly recall. I can't be sure.
We could take Exhibit 15 down.
Thank you. Go ahead.
And you said you stayed at the parade until your group had passed.
Correct.
And what time did you leave?
I can't determine the time. It was right after my group of kids went by.
And where'd you go from here?
I walked down, well, I went to go get the car because I had to go pick them up at the end of the parade.
And I'm assuming at some point your attention got drawn to something happening. That'd be fair to say?
Not necessarily.
What do you remember when you went to go get the vehicle to pick up members of your group? Would that be fair to say first? I don't want to assume.
Yeah.
Do you recall anything happening at that point?
A situation did occur before the said big event that took place.
What do you recall happening at that time once you were on your way to get your vehicle?
I think I need more specifics from you to give the details you may be looking for.
While you were getting your vehicle, did you observe anything happening? Did you overhear about anything happening at that point?
Nothing of that nature. Well, all I can say is that I was walking past White Rock.
Did you see anything that may have alerted your attention at that time?
Yes, a car coming through the parade at the beginning on White Rock where the parade was starting. So when I left, I walked down Main to White Rock on the corner there. Then a gentleman, a child, who I don't know who they were, and myself walked across the street. And at this time, a car was beeping and weaving around a slight curve that White Rock has, and then continued on.
Did you see Did you see where the car went at that point?
Yes, I did. As it came around the slight curve White Rock has, it started to move forward, and then it went straight across when I was thinking it was going to leave the parade route. If you leave the parade route on Main, you're leaving. Sorry, if you turn left, you're leaving the parade route. If you're turning right, you're going right into the parade. And it went right to the, if you're looking at the parade, it was on the right-hand side. And it's continued on into the parade.
Hold on, just for the record, she was using her hands during her testimony. I just need,
Left.
that's okay. I just need to make a
Yeah.
record of it. Usually her right hand just kind of demonstrating the course of travel that she described, the vehicle. And I think that's probably all I need to put on the record about that. Go ahead, next question.
I want to back up a little bit. When you first observed this car, as you say, you recall that it was blowing its horn.
Yep, it was, the horn was beeping.
Do you recall if you saw who was operating that vehicle?
Unfortunately, sir, I can't recall.
Do you recall if you might have seen multiple people in the vehicle at that time? Or?
You know, unfortunately, due to the time passing, I cannot recall.
That's fair. It has been a while. Do you recall about what time that was that you observed the vehicle?
Again, I can't be sure.
Sorry if I keep asking.
No,
stuff.
I can't be sure. I'm sorry.
At the time that you observed the vehicle, did you see it strike anyone?
I did not, or at least I don't recall. I'm sorry.
And do you recall if the vehicle was speeding at that point that you observed it?
It wasn't speeding, but it was. All I can state is it wasn't speeding.
Did you happen to catch the license plate number of the vehicle at that time?
No, not at all.
Do you recall if the vehicle had any tinted windows?
I couldn't recall. I'm
Any
sorry.
windows rolled down or up at the time you observed it?
No, unfortunately, I don't remember.
Do you recall if the vehicle passed close to where you were walking at the time?
Yeah, it was close enough that it could have easily have clipped me or the two people that were in front of me.
Where you were, the two people that you referred to in front of you, were any of you hurt at that time?
No.
No further questions right now.
Hey, Cross.
Yes, thank you. Good afternoon, Mr. Rell. Thank you for being here. Is that when you saw this vehicle we've been talking about?
Yes,
So you were standing in the crosswalk.
correct.
Do you remember a police officer being in that intersection?
I can't be too sure.
Okay. Was it clear to you that this was a parade route?
Yes, it was very clear.
Was it clear to you that traffic from White Rock should not have driven onto Main Street
Yes,
unless they were part of the parade?
yes.
Did it appear to you as though the vehicle we've been talking about was part of the parade?
No.
How many children do you have, Miss Urell?
Objection irrelevant.
Overruled. Who may answer?
4 children.
All 4 of your kids were marching in the parade that day, weren't they?
Yes.
Objection leading.
Overruled.
Sorry.
Your oldest daughter, Charlotte, she was 14 at the time?
Yes.
Thank you.
She was marching with the Extreme Dance Group as an alumni, wasn't she?
She was handing out candy.
Objection.
There was an objection, it's overruled.
I didn't even state why I was objecting, but okay. We still need a 15.
Yes, please. You see on that map the 5 Points intersection?
Yes.
When you were standing in the crosswalk at White Rock in Maine, could you see the 5 Points intersection?
I could not.
You didn't see your kids get hit, did you?
I did not.
Objection leading.
Sorry.
Overruled.
Again, sorry.
Objection hearsay.
Overruled.
You didn't.
I did not.
Did you see them later that night?
Objection leading.
Overruled. You may answer.
I was only able to see 2 of my children that night.
When did you see the other 2?
Days later, when I was able to leave Children's Hospital.
As their mother, you were directly involved in their medical care and the decisions that were made in that process in the days after the parade?
Objection leading.
Overruled. You may answer.
Yes, their father and I.
Charlotte suffered a chipped vertebrae from being struck, didn't she?
She did.
Objection
Sorry.
leading.
Overruled. You may answer.
She did.
Your daughter Alice, she was 10 at the time, wasn't she?
She was.
She suffered chipped front teeth, is that correct?
Yes.
And facial scarring
Yes.
and road rash
Yes.
and a broken fibula and tibia
Yes.
and broken metatarsal bones.
Yes.
She was observed in a concussion protocol, is that correct?
She was.
Your daughter Vivian, she was marching with the extreme dance group too, wasn't she?
Yes, she was.
How old was she in November of 21?
She just turned 7.
Vivian suffered a severe concussion, didn't she?
Objection leading.
Overruled. You may answer.
Yes.
And road rash
Extreme road rash.
and a lung contusion
Yes.
and facial scarring.
Yes.
And your 7-year-old daughter Vivian suffered a broken tailbone, didn't she?
She did.
Your son Grayson, he was 8 on November 21st, 2021, is that correct?
That is
Objection
correct.
leading.
Overruled.
He was walking with the extreme dance group handing out candy, is that right?
He was.
He went to the hospital after the parade, didn't he?
Yes.
He suffered a compound fracture in his femur, is that correct?
An open compound fracture.
Meaning the bone came through the skin?
Yes.
Objection hearsay. I don't believe he's a doctor.
Overruled. The witness may answer based upon personal knowledge.
Was that a yes?
Yes.
A police officer saved Grayson's life by placing a tourniquet on that open leg wound, is that correct?
Yes.
I don't have any other questions.
Any redirect?
No redirect.
No redirect. Are you realizing how fucking dumb that was, you moron? You brought that woman up there, asked her a bunch of pointless ass questions, and that's what happened to her kids? Is your argument, but I didn't kill him, no?
Brilliant, Darrell. Brilliant. You must not have realized that was coming, did you? You didn't do your fucking homework. Yeah, you're covering up your mouth like, oh God, you're trying to hide. Ain't nowhere to hide for you now, you dumb shit. The jury just saw that. Bravo, Darrell. Bravo. Fucking raise your hands high, champ. Raise your hands held high, champ. Brilliant.
So, and like Brooks trying to look upset here. The only thing he's upset with is just how badly that went.
Yeah, the only thing he did right there was say no redirect.
Yep.
We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 35, count 36, count 37, count 38 information. Dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes.
Out of curiosity, how did you come to the knowledge of that name?
It was on the subpoena I received last week.
You just stated a little bit earlier in testimony that you received your subpoena in July. Now you said last week.
Those are both correct.
So you received 2 separate subpoenas?
Correct.
What was the difference between the 2?
One was from the district attorney's office and one was from you.
So the one that you received from the district attorney's office in July didn't have a case caption on it?
Okay, what's a case caption?
Just 1 second. 1 second, Your Honor, if I may
just
have
gonna
it.
object to this line of questioning. I really don't know what the relevance is for the purposes of this trial.
There was no objection at first.
But there's now.
I'm going to sustain the objection under 906-11, because I don't believe it advances.
I think
trial.
I think you know where I was getting at with the question.
Then you need to ask your question directly, sir. Go ahead. But I'm sustaining it as to the form of the question.
When you were subpoenaed in July by the district attorney's office, the subpoena didn't contain information to the case you were being subpoenaed for?
Objection to relevance.
Grounds?
Sustained. You don't have to answer that. I sustained the objection on those grounds. Ask the question I believe that you're trying to ask, not that one.
Was the name that you mentioned, Mr. Brooks, anywhere on the subpoena that you received from the district attorney's office in July?
Objection. Relevance.
Grounds.
Sustained.
Grounds for the sustained. That
Not
was
relevant.
What? Mind-boggling. Sir, in July when you received your subpoena from the district attorney's office, were you even aware what you were being subpoenaed for?
Objection. Relevance.
Grounds.
Sustained. Not relevant.
She's testifying in the trial and it's not relevant that she got subpoenaed?
Mr. Brooks, she's here under your subpoena.
What?
You called her as a witness. It's
The
your
subpoena is relevant because she
Mr.
was
Brooks,
already
under
subpoenaed.
90611, please ask the witness a
This is
relevant and
mind-boggling.
probative question.
This is mind-boggling. Mind-boggling.
Remind the jury that the statements of the parties or the attorneys are not evidence.
So were you aware that it was a chance you would be possibly testifying in this trial?
Yes.
And did you know who the trial was for?
Objection.
Grounds.
Sustained.
Grounds for the
relevant.
sustained.
It's not relevant.
I've never heard of nobody testifying in a trial that they didn't know who the trial was for.
Mr.
think
Brooks,
I think
I'm
that's very
sustaining the
relevant.
objection under 90611, and I'm asking you to move on.
Y'all, this ridiculous, man. Seems to me like a lot of your answers are coached. Is that fair to say?
No.
So the subpoena that you got last week, Is that how you learned the name that you used?
Objection.
Grounds.
Relevance for the same reason I argued before.
Grounds.
Asked and answered. She's indicated the answer already. 90611, sir. Next question.
The question
Different
was,
topic.
is that the first time that she saw the name?
It's not relevant.
That
Next
was not
question.
asked and answered. That was not asked nor answered.
Under 90611, please ask a question, sir.
Man, what is y'all people trying to pull up, man? This is ridiculous.
Mr. Brooks, if you don't ask another question that's relevant and probative under 90611, then I will turn the witness over to the state for their cross-examination.
And then I should be able to get redirect, right? Your Honor?
Ask a question, or I will declare the examination by you to be ended.
It's not an examination, it's direct.
It's a direct examination, sir. Under 90611, you are directed to ask a question, or I will ask the state if they have any questions.
I heard you.
Thank you. Next question, please.
Know who the plaintiff is in this matter?
Yes,
Who's the plaintiff?
the state of Wisconsin.
Is that an entity or a living human being?
Objection.
Grounds.
Relevance.
Not relevant, sustained. Next question.
Have you ever had any interaction with the plaintiff?
Objection. Vague.
Sustained.
Vague.
As to the form of the
Have
question,
you ever had any interaction with the state of Wisconsin?
do not answer that question. Next question, sir. Under 90611.
Was there an objection or was that just a ruling? I'm not sure. You're both was talking at the same time.
Under 90611, I directed the witness not to answer that irrelevant question. Ask your next question, sir. Mr. Brooks, ask your next question.
I'm going to get to it.
Thank you.
So when did you first report your alleged injury?
You do not have to answer that question. Next question, sir.
Grounds for
90611, sub 1, sub A, sub B, and sub C.
is that lawful law?
All right, you may sit down. Does the state have any questions for this witness?
Ma'am, that day on November 21st of last year, you were there with 2 kids?
I was, yes.
What were their ages on that date?
Objection.
3
relevancy.
and
Overrule, the witness may answer.
Of course it's going to be overruled.
3 and 6.
And I don't know, Mr. Brooks can sit down. I'm kind of asking the questions right now.
Mr. Brooks, please sit down. Mr. Brooks, you're not asking the questions.
I'm not saying
I would
anything.
ask you to sit down, please. It is disrespectful to this witness and to the state and to the court.
No, it's not. Not doing anything wrong. I'm merely standing here.
And when you were at the parade on November 21st of last year, approximately where were you watching the parade from?
Asked and answered objection.
Mr. Brooks, it's cross-examination. Just because you asked the question initially and she answered it does not mean the state doesn't get to follow up on it.
So the state can ask the same question I
The
asked.
state can ask their question.
So how
Go
come when
ahead.
I did that,
Overrule,
it was
the witness may
it was
answer.
sustained?
I was on Main Street, but right by where the intersection of White Rock, and I was in the roadway.
I'm going to show you what's been marked and previously admitted into evidence as State's Exhibit 15.
Go ahead.
And I'd ask that the screen be cleared. And ma'am, does this show...
Wait till it's in the jury box.
sorry.
I'm sorry. The jury would let me know when it's there. Thank you, it's there now. Go ahead.
Ma'am, do you see a purple line on that would indicate the parade route going from White Rock Avenue down Main Street?
Yes, I do.
And can you approximate where you and your kids were watching the parade?
Yes. Do you want?
I'm sorry, it's a touch screen. I keep forgetting to say that. It's touch screens, just put a dot right where it is. Okay.
Maybe on the other side of that red line?
So, okay, can we clear the screen and maybe just put a dot? I think that, or a circle. I think a circle would be good. Okay, thank you. Would be fair to say is to your left would have been Pleasant Street?
That is correct.
Were there barricades blocking Pleasant Street?
There were
Overruled, the witness may answer.
there were barricades that were partially blocked. They were on Main Street, but partially blocking Pleasant Street as well.
Could a car have gone down Pleasant Street?
Yes.
Objection.
Okay.
Overruled,
Hearsay.
the witness may answer. It's not hearsay.
So when the red
Hearsay.
SUV came down White Rock Avenue and was making its turn onto East Main Street, as you've testified, it could have just gone straight onto Pleasant Street, correct?
That is
Objection.
correct.
That's hearsay. She's speaking as a
Hold
first
on.
eyewitness,
There's an
first-hand
objection.
eyewitness.
Mr. Brooks, your objection is noted. It's overruled. The witness
As
may
usual.
answer.
It's always overruled.
Go ahead, you may answer, ma'am.
Sorry, there's a lot of talking. Your question was, just to clarify, could the vehicle have gone straight onto Pleasant Street? Is that right?
Yes.
Okay, yes.
Okay, thank you. And where you stated that you and your kids were partially in the roadway when the red SUV came through?
Yes, we were.
Objection. That's mischaracterization of what was testified to.
Overruled, the witness may answer. Go ahead.
Give me an answer.
Can you repeat it?
Sure. Were you and your kids all in the roadway when the red SUV went through?
Yes, we were.
Okay. You weren't part of the parade, correct?
We were not.
Okay. So were you standing with other people that were in the roadway?
Yes, we were.
And was one of your kids going to get candy when the red SUV came through?
Yes, my
Objection.
daughter.
Speaking as a first-hand eyewitness.
Because she is a first-hand eyewitness.
No, I'm talking about you.
The objection is noted. It's overruled. The question is proper, and the witness may answer.
Yes, my daughter was further in the roadway. We were all in the road, but she was further in the roadway, reaching to grab candy.
At any other time, you stated that this was towards the end of the parade. Is that correct?
Yeah, we saw Santa, and he's always like the end of the parade.
And had your daughter gone to get candy at other times?
The entire time.
Had she, during the time preceding the red SUV coming through, had she almost been struck by any other participants in the parade?
No, she was nowhere near like where the vehicles were driving through the parade. She was no.
So she's going out to get some candy that had been thrown, I assume, correct?
Yes.
And
Overruled. The witness's answer may stand.
you see this red SUV coming. Is it coming from your right or from your left?
The red SUV was coming from my right side, which was White Rock.
Okay. And how close did it come to your daughter?
It was, I wouldn't be able to give an accurate judgment, but it felt very, very close.
Had you not pulled your daughter away, would that car have hit your daughter?
Objection is speculative.
Overruled.
It's very possible.
So you say that you saw a police officer have some contact with the red SUV. Do you recall that?
Yes.
Can you describe that for the jury?
Well, there was a few times that police officers attempted to stop the red SUV. The first one would have been where we were on Main and White Rock. And then there were also other people trying to stop it too. And then again, as it drove, once it turned onto Main, the next road, I believe is Buckley. And there was another officer who tried to stop that red SUV again.
And which is the officer who had to step out of the way in order to not get hit by the red SUV?
What was the question?
Where was the officer located who had to step out of the way to avoid being struck by the red SUV?
I believe that was the officer around Buckley and Maine.
Okay. And ma'am, as the car passed your location, did it increase its speed?
Yes.
Do you know where in the roadway it traveled down?
Overruled. The witness may answer.
The direction of travel?
Where in the road? Was it on the left-hand side, the right-hand side, or in the middle?
It was all over the road.
You saw it all over the road?
Yes.
So going, and why don't you describe for the jury what you saw?
Driving the vehicle, once it turned onto Main, it drove side to side, and then I lost sight when there were through the people as it got down the hill.
Nothing further.
Thank you. What do you think, Darrell?
Yep. You said you observed multiple officers try to stop the vehicle. Is that correct?
Yes.
You described one at, I think you said it was Buckley, right?
Yes.
Why didn't you report the other officers that you allegedly saw attempt to stop the vehicle?
I don't know what you're asking.
The report that the interview that was conducted with the FBI, that was who did your interview, correct?
Yes.
Why is it not in the report about the multiple officers that you say you saw attempting to stop the vehicle?
I don't know why it wasn't put in the report.
Do you recall if you told the FBI agents?
It's been a year. I believe so, but it's been a year.
When you say it's been a year, I'm assuming that means that there's some details you don't quite recall all the way. Would that be fair to say?
Yes.
So it would be fair to say that if there's details you don't recall, how can you recall the path of travel of the SUV that you claim you saw?
Can you rephrase the question? I'm not understanding.
I think it was clear, but I'll ask again. You just acknowledged that there may be some details that you don't quite recall. So would it be fair to say that you don't quite recall the path of travel of the vehicle?
No, that is not correct.
Judging by what you just stated, wouldn't it be fair to say that that's a possibility?
No.
So you recall all the details of what you observed that evening, November 21st, 2021?
No.
So what other details do you not recall?
Objection. Your Honor, how does someone recall the details that they don't recall?
Yeah, that's what I wonder.
Sustained is to the form of the question.
Seems very funny. Seems almost as if you're recalling what you want to recall and purposely not recalling.
Objection. Badgering the witness.
Yes, sustained. You do not have to answer that, and you are warned. You may not badger or argue with this witness. Next question.
Badger or argue? What do you mean?
Next question.
What do you mean?
Don't intimidate the witness is what I mean.
How am I intimidating the witness?
Badgering the witness by eye rolling, by pursing your lips, by making facial movements regarding her
Does she
answers
feel intimidated?
is badgering the witness.
Are you kidding me?
Under 90611,
You really
please
can't- you
ask
really
your
can't
next
be serious.
question.
You can't be serious right now. Intimidating the witness. What have I done to intimidate the witness?
The last question was badgering, which is a form can
But you
be.
said
Mr. Brooks, I've made my ruling under 90611.
specifically
Please
said
ask a
intimidate.
question or
I'm trying
I
to
will
merely-
stop the
How
questioning.
did I intimidate?
Under 90611, sub 1, sub A, sub B, and sub C, ask your next question or the questioning of this
How are
witness
you
will
even a
end.
judge? How are you even a judge?
All right, you may step down, ma'am. Thank you.
How are you even a judge? Come on, man. This must be all about the 62 trust, right? That you want to be the beneficiary of?
I'm going to give the jury their closing instruction. We are done with testimony for today. Please do not begin your deliberations and discussion of the case until all the evidence is presented. And I have instructed you on the law. Do not discuss this case among yourselves or with anyone else until your final deliberations in the jury room. This order, thank you, you are excused. Please rise for the jury.
Call yourself a judge as much as bias you could put up in here. Don't even tell the jury the truth. Got no integrity whatsoever. None. None.
Thank you, everyone. Please be seated. I would like an update on whether Mr. Brooks filled out a subpoena for Dawn Woods and provided that to the state. Has that been done?
No, we haven't received anything, Your Honor, and obviously she can appear here voluntarily if Mr. Brooks wants to arrange that. I don't believe a subpoena is necessary. We had subpoenaed her, and she was under state subpoena. So I know that at least some point she had notice, but our position would be, Your Honor, that we will not be responsible in any fashion for producing Miss Woods. Mr. Brooks talks to her on a daily basis. If he wants her here, he can produce her on Monday.
Yeah, they ain't got to worry about that.
So I just wanted to know, because I know a subpoena form was filled out.
If
So
I want her to be here, she gonna be here.
I agree with
So
the
just
state
just know that.
She could certainly appear.
It ain't even got to be no arrangement. All I got to say is come. She gonna come. That simple.
Mr. Brooks, do you intend to call her as a witness? Because I'm directing you
We
to
said-
have her
we
here
said
at
all
9
that-
a.m.
We said all that at the beginning, man. Like, I don't even want to be in here that much longer. Just do what you got to do so I can get up out of here. I'm tired of being in the courtroom that has no integrity whatsoever. How can you even call yourself a
Mr.
judge?
Brooks, I need to make a record of
I need to make a record too.
You don't
When
need
am
to-
I going to get the chance to do that?
All right, I need to make a record. He's being removed to the other courtroom. He is yelling at me. He's not going to let me make a statement or make the record that I need to make.
I'm finna
He
leave
hasn't
anyway,
sat
so
down
what do it
for
matter? You
the
can
better
hold me
part
in
of 2
contempt
hours.
all you want. You can hold me in contempt all you want.
I'm not
All
holding
you
you in
gotta do is tell me
contempt.
if it's criminal or civil, so I can hit
All right,
you with you.
I need to
with
clear
what you
the
know is
courtroom because
coming.
I do need
I'm
to
gonna
make-
give you what you know is coming.
I need him to go to the
If
other
it's civil-
courtroom because I do need to put some
If
things
it's
on the
civil,
record. The record should
Where's the
reflect
contract between you and I?
that Mr. Brooks
If it's
is
criminal,
yelling at me.
what is the crime?
He is.
Who makes the claim? And what
He
is
is. I will make the record when we get back. I will step off, but Mr. Brooks, you're being
It ain't
taken
no
to
Mr.
the next
It ain't no Mr.
courtroom.
Brooks. Don't try to address me
Thank
like
you.
that, like we cool. You don't have no integrity. How can you even call yourself a judge? Making tacit agreements, being biased, judicial misconduct, trying to steal somebody's system. How would the alleged defendant obtain photographs from you if there's been no contact?
Objection.
Grounds.
Suspect, not in evidence.
Grounds.
Sustained. Assumes facts not in evidence, not relevant.
How's it not relevant? Photos just don't pop up out of the blue.
Mr. Brooks assumes facts not in evidence,
No,
and
it's facts.
this point
I got the pictures
conduct
right here.
after
Facts.
the alleged date of violation here is not relevant.
Alleged violation.
You're
For the record.
correct. After the date charged, that the dates that are charged for these allegations, you are absolutely correct.
Thank you. Have you, since the evening of November 21st of 2021, have you attempted to contact the alleged defendant?
Objection.
Grounds.
Relevance.
Grounds.
I'm going to excuse the jury. All right, sir, I'm going to let you make an offer of proof as to why you believe the photographs and the questioning about contact after the alleged incident is relevant.
It's relevant because these were sent by the witness.
It assumes a fact not an evidence, but
You
what
want
is...
the letter
hold
too?
Hold on. Tell me the basis you believe there's been communication and why you believe it's relevant to her testimony.
It's relevant because it was testified to her first time testifying, and then also by what's the last guy, Guth, that he was told that the witness was supposed to be so deeply afraid of me and all this type of stuff. So if you're so deeply afraid and worried about somebody and this and that, why would you sneak and have
Do you want
contact?
to open up the door to the other act's evidence of
That's
you
not
use-
opening.
No.
That's not
Hear me
opening the
out.
door.
Hear me out. Oh, yes, it does.
No, it doesn't.
These witnesses have been incredibly careful to abide by my rulings. Sometimes in a court of law, when there are pretrial rulings, the testimony of a witness needs to be said in such a way not to run afoul of that. This witness, Detective Guth, I believe Detective Casey and others, Corey Runkle, and even Nicholas Kirby yesterday, this court has all had to stop them so that they didn't run afoul, or they've stopped themselves so that they didn't run afoul of the court's pretrial ruling on other acts evidence between you and this witness. And I have been very, very careful to make sure that doesn't come in. But if you keep questioning her about whether she's afraid or not, or
I
why she
didn't
wouldn't
question her
have
about that.
contact or
I
not,
didn't
you are
question her about
opening
that.
the door to that testimony. All of
How
my
does-
rulings
how
have
does- how
been
does-
made to prevent
how
what
does
could be
pictures
seen
run?
as prejudicial evidence. The standard's not prejudicial. The standard's whether it's unfairly prejudicial.
It's
But you
unfairly
can
prejudicial.
open the door
Your
to
Honor,
that,
It's
sir.
unfairly prejudicial that I have a document stating that November 20th never even happened, but yet and still the witness
Then
can
have
get on
you
the
turned
stand
that
and lie on the
document
stand.
over to the state?
Come on, man. Y'all know that's not right.
It,
Y'all know that's not right.
then you need to immediately turn it over to the state right now. It may become relevant, but no one has seen it. When
So-
did you receive the
so that- so
document?
what-
Hold on. When did you?
Wait.
I'm having you make an offer. When did you receive the
Okay,
document?
but that I just want to state for the record, Your Honor, that's kind of biased because the state did the same thing yesterday with creating an exhibit right on the fly that didn't even exist that I didn't have. But
That's
then,
not true. That's a
no,
misstatement of the
that
evidence.
is true.
No.
She said it herself.
No. Marking an exhibit is not creating an
No,
exhibit.
not marking the exhibit. She said
We're not
that
going to go
essentially-
down a tangent, sir.
All right,
I'm going
I'm
to
not gonna
focus
argue
on
with
this,
you,
and I'm
but
going to
it's
give
not
you the
fair.
opportunity
It's not
to make
fair.
a record.
It's not
All right?
fair. It's not fair. Your Honor.
When did you receive this document that you claim was sent by this witness?
It's not claimed. It's for a fact.
Sir, it hasn't been established yet. I need to make a record.
So do y'all want
I
the
want
letter?
to see
Y'all
the
want the
letter.
envelope? What?
I want to see the letter.
Okay, so I gotta.
And I wanna
so now
know
I gotta
when you
bring that in.
received it.
Now I gotta bring that in. Every time, this is what I don't get. Every time I'm presenting something that needs to be made for the record and placed in the evidence, it's a problem. But the state can do it, no problem.
It's not, sir. There are proper procedures, and I
Okay,
want
well,
you to
that
make
was the
a
proper
record.
procedure.
If you don't make a record,
So
then
what?
I can't make a ruling.
It threw people off a loop. They weren't ready for it. They scared of it. That's what it is. Come on, man.
Mr. Brooks.
Come on, man. Stop.
When you
Stop
are
it.
you aren't
Stop
even
it.
letting
You're a
me
public
ask the
servant, Your Honor.
questions.
I respect your courtroom. I
You
respect you. You're a public servant, though. Your job is to be the referee. Is it or is it not? You stated so yourself on record that your job is being the umpire.
Your Honor, can I ask Ms. Patterson please be excused?
Yes, you can be excused. My apologies.
My apologies too, but it needs to be some truth. Especially when we're talking about stuff that didn't even happen, but they're allowed to get on the stand and say that it happened when they know it didn't happen.
So I'm going to make a record about what
This
he's
is
referring
ridiculous,
to
man.
in count 77. Okay. The
And
state-
what happened to that paper? Because it was on the table. Then when I
Mr.
come
Brooks,
back in,
I
it's
need to
nowhere
make
be
a
found.
record of a variety of
So who
things.
took my paper?
And you keep interrupting me repeatedly today. I have shown an abundance of patience this morning. I've warned you repeatedly about being removed from the courtroom. And then every time I try to get into it, you, meaning an explanation and make a record, you interrupt, you attempt to divert everyone from what is being done this very second.
I didn't attempt to do anything.
Yes, you do it repeatedly, sir.
whatever.
So you're doing it once again.
Whatever. Just make your record.
The document that Mr. Brooks wanted to show Detective Guth and this witness was a letter sent from the state of Wisconsin to the court regarding count 77. The state sought to dismiss that count, and they have prosecutorial discretion, and I granted the request that the charge be dismissed.
Why was the charge dismissed?
And that's, I can't answer. It was dismissed because the request was made, sir. They don't need a reason. There's an abundance of case law about prosecutorial discretion. And they chose not to pursue that. My guess
Your Honor,
is maybe
with
to
all respect-
simplify things and to keep this tidy. I don't know. You know what? I'll indulge you. Attorney Upper, would you like to provide a basis for why the state sought dismissal of that charge prior to the start of this trial?
Yes, Your Honor, because as Ms. Patterson just testified a short while ago, she did not have any visible marks or injuries from that event. And we did have the photographs of her injuries. We did not want to confuse the record as to whether or not there was a battery that occurred on November 20th.
Your Honor, I object to that. What does the letter read?
You have the letter. You showed it to me, sir.
I tried, yeah, and I've been trying to find it ever since I came back in, and now all of a sudden I can't.
And now
find
you're
it.
impugning, though, like somehow you're imputing the integrity of this court,
No,
of
I'm
the
not.
bailiffs of this state. You're accusing, frankly, everyone
Did I
of
point
moving
the
your
finger?
papers.
Did I point the finger at anyone? Did I say anyone did anything?
Not directly, but indirectly you did,
So
sir.
how can you make the assumption that I'm saying?
Can
that
I
I'm
please
pointing to
make the
someone?
record without
Yes,
you interrupting
yes, you may.
me?
Yes, you may. I apologize.
I appreciate that. Thank you. But you made repeated comments, sir, about I can't find my documents, I don't know what happened, things of that nature. When you came back out, you took multiple minutes before you even asked your first question of Ms. Patterson. And if I need to, I'll have a bailiff put on the record that no one touched your table.
Your Honor, did I say anyone touched my table? I didn't
You
say
implied it, sir.
But did I say that?
You stated it implicitly.
I never asked the bailiffs, hey, did any one of you touch my table? I never said that to them. I just said, I can't find my paper, which is the truth.
And the way that you said it, like,
I didn't point anyone out, though.
And like,
I
well,
don't
that's
think that
kind
that's
of
fair.
interesting.
I don't
I don't
think that
have a
that's fair to
document that was
assume.
just on my table. That is what you said.
That's
Words
what
to
I
that
said, but I
effect.
did not point the finger at anyone.
So,
I
you
can see
have
if
the
I
letter.
came in, Your Honor, with
You've
all
been
respect,
given.
I can see if I came in and said, hey, one of you moved something off my table, or if I would have directed that towards the state, or if I would have directed that towards the clerks or something like that, then that would be more of a validity to what you're saying.
I need to continue with the record, sir. Number one, when did you receive this letter?
I received this multiple letters, actually, over a period of time. It wasn't, I referred to this one because this one had the pictures. But
And why do you believe
one,
it was from
to
Ms.
answer
Patterson?
to answer your question with clarity,
Thank you. Does it have a date on it? The letter?
no, I didn't bring the letter, I brought the pictures. Because I thought, from my interpretation, I thought showing the pictures would be okay. How did I get these? So my mind was saying, show the pictures. They didn't come out of thin air. The witness
We need
knows
the
that
letter.
they sent me the pictures. They know that.
Well, again, it assumes facts that aren't here. You're assuming this witness sent it. I don't know. But even if she did, what relevance does it have to her credibility before this jury?
It goes to the credibility because she's put on this facade of being so afraid of someone, but yet still, you know that we're not supposed to have contact, but you still sneaking behind and saying, oh, I wonder how you're doing, and oh, this and this and that. Oh,
I don't think
you know,
she's
I still
ever
love
said
you.
she was
Oh,
afraid. I
mhm.
think that was the officers who may have stated that. But I don't believe she
But-
ever said that. She specifically said today when you asked her why did you, it was either why did you go back or why did you have, I'll look at my notes, and she said, I don't know.
It was why weren't you forthright with all the details? That was the question.
So again, I'm going to ask you, even if this letter's from her, these pictures are from her, how does it
Your
relate
Honor.
to her credibility before the
Who
jury?
else could these pictures be from?
I'm going to ask you point blank. Did you get a letter that's signed from her?
I got. What do you mean signed? No
How
one
do you know?
signs letters.
What's your why do you have a belief that they are from her?
I have multiple letters from her.
You're not answering my question. Why do you believe the letters are from Erica Patterson?
Because they were sent from Erica Patterson. Why else would I?
Were they signed by her?
What do you mean signed?
Did she write her name on the letter? Was
Are
it the
you-
content
are you
of the
kidding
letter?
me?
No, I'm not kidding you. I need to make a record, sir. You're making a statement that these letters are from her and that they're relevant to her credibility.
Your Honor, I'm gonna go out on a limb here.
And I'm asking you why you hold that opinion.
I'm gonna go out on a limb here and assume, which I know is true, you've never been in my position. You've never been in jail. So you've never received a letter from someone writing someone in jail. No one is gonna. When you
You're
say
not
to me,
answering my
when
question,
you say to
sir.
me,
What's the basis why you believe they're from Miss Patterson? Is there some information in them that only she would know? Did she sign the letters? Is it penmanship that you recognize? Why do you believe they're from her as opposed to somebody else sending you information? Could be your mom, could be, I'm just saying, could be anybody else. You got to answer my question. It's called an offer of proof.
But you still got to understand why this is mind-boggling to me. Like, how I got a child with this woman. Why would I not know her handwriting?
But you have to lay a foundation for these letters, sir. That might be through your own testimony. So that I'm trying to figure out why you believe they're from her. Not all this other stuff about I'm in jail and I have a child. I'm trying to I need to know. It's called an offer of proof.
Are you serious?
What do you believe? Why do you believe they're from her? I am serious.
Because they're from her.
But you're assuming
how else am I supposed to answer that?
I've given you a few reasons why it would lend to that opinion.
So it has to be put in a legal term.
The bottom line is I need the letter. So if you're going to question her on that, the state absolutely has a right to see the letter. So you need to provide that letter. The bottom line is I'm not going to allow any questioning without having that letter. So the state has the ability to question you about that, or question this witness, and to look at the veracity of what your claims are here. So I may take an early lunch. If that's in your cell, then you can go get it and bring it. But without that letter, I'm not allowing this line of questioning. Do you have the letter with you in court?
I just said no. How many times I got to say the same thing on record?
You know, sometimes, sir, I don't hear what you say because you interrupt me so much or you answer quietly. And I'm taking notes and I'm focused on probably a dozen things at the same time.
But if I say something under my breath, everybody seems to hear it. Everybody seems to hear that just fine.
In a quiet courtroom, yes, we can hear it very clearly.
And everybody assumes that it has to be disparaging.
Once again, you're doing this tactic.
Because it's not a tactic, it's facts. It's facts.
To some other reason.
It's facts. Because I find it hard to believe that
I'm gonna
all of a sudden nobody hears what I say.
I'm going to let the state make a record of why they believe it's objectionable, because I haven't let them do that. I've given you multiple opportunities to tell me why you believe it's...
I didn't get these pictures from nobody else. Why was somebody else...
The record will reflect you have 2 pictures that you believe were from this witness.
That I know is from him.
No, that you believe.
That I know.
All right. I'll ask the state their position on all of this.
My position, Your Honor, is that these pictures, first of all, should not be admissible. 1, because of a discovery violation. We've never seen them before. 2, because we have reason to believe that he did not get them from Erica Patterson. He is on a jail phone call talking to his mother, Dawn Woods, about Dawn Woods sending these photographs to him. Now,
that's a lie. I object to
that.
Let
the state make their argument without interruption, sir.
That's a lie, though.
3, I believe that these photographs are designed to make a suggestion to the jury that Erica Patterson is a bad mom. I think that is what the defendant is trying to do. And if we're going to go down that road, then we would be forced to counter that claim. First of all, it doesn't make her an incredible witness, if it's even true. And second of all, if we go down that road, we would be forced to counter that claim by pointing out that not only does the defendant not live with the child in question, he doesn't live with any of the other children that he has. He impregnated Erica Patterson when she was a minor in Nevada, and for doing so, he was convicted of statutory sexual seduction, pled guilty in March of 2007 to that felony offense, and is a sex offender on the registry as a result. So if there's any causation that would lead to Erica Patterson being a bad mom, Mr. Brooks has a direct role in that causation.
And that's
furthermore,
I object to that.
I'm not
because that's a lie.
Let him
finish. At the end of the day,
if
we're gonna open the door on that, no, since he want to make a record and not be accurate, so let's be accurate all on the record. Since you think you know so much,
once
so
again,
we can
Mr.
open the
Brooks
door on.
is being
We can
loud,
open the door on how old she told me she was when
interrupting.
we met. We can ask that question
he is
too. Then
over the
Did you
top
ask
animated
that? Did
right
you know
now.
that?
Mr. Brooks, I'm ordering you to sit down and to let the state finish.
No, I'm not going to sit here and let somebody be inaccurate on the record and lie on the record.
Right. Under Illinois versus Allen, I've warned him repeatedly. He's being removed from the courtroom. And you know what? Let me dial that back. We're just going to take an early lunch, 1 hour. We'll be back. And unless he brings that letter, and he can show it is inadmissible, she will not be questioned, and under 906.11, I will declare the cross-examination closed. Thank you, we're in recess, 1 hour.
Get your facts straight. So let's open the door on all of it then, so we can get all of it on the record. Since you think you know so much. Did you know she said she was 18 when I met her? Did you know that?
Make a record about relates to the testimony of Erica Patterson. So for the record, I think it's important to note that the two photographs the defendant attempted to show that witness and presumably put into evidence depicted what I believe to be the defendant and Miss Patterson's 15-year-old daughter, as well as their new grandchild, the daughter's child, who was born around May 1st of 2022. I think that there was ample grounds for the court to end Miss Patterson's testimony when it did, but for just in case that becomes an issue going forward, I'll make an offer of proof that Miss Patterson, if asked about those pictures, would have testified that she did not provide them to Mr. Brooks. She provided them to a person named Michelle, who I believe is a mutual friend, who in turn provided them to Dawn Woods, the defendant's mother, long day, who then, that was the person who provided them to Mr. Brooks. If she were forced to answer questions about this supposed letter that Mr. Brooks was claiming to exist, she would have testified that she has not written a letter to Mr. Brooks since he came into our jail on November 22nd. She never went on November 21st either. At any point between his being taken into custody and today. It's my understanding that he has tried to call her from the Waukesha County Jail on 37 occasions. She has never accepted a single one of those phone calls. And finally, during the early lunch break, I was informed by the bailiff staff that the defendant was twice offered to go to his cell to retrieve that letter that he talked about. He declined both times.